So hi everyone. Today's unit that we'll be doing is company law, and we'll be doing learning outcome 4, which is to understand the legal procedures related to corporation liquidation. My name is Shazia Khan, and I'll be discussing learning outcome 4 with you today, and then the final learning outcome will be the assignment discussion. Before I carry on with learning outcome 4, I just want to give you a summary of what we did in the last session, which was learning outcome 3. In the last session, we were looking at understanding the rights of shareholders and minority shareholders. We looked at 3.1, which we looked at analysing the rights of shareholders in public and private limited companies. We looked at the right of shareholders in public limited companies firstly, and we looked at the issue of transferability of shares and how that works. We then went on to look at the issue of liquidity of investment, and we went on to look at the voting rights, access to information, dividend rights. We also looked at rights of shareholders in private limited companies and how they would look at voting rights and limited liquidity and transfer restrictions, and how they face restrictions with their private limited company. We looked at limited access to information, dividend policy, and why that was so important. We also looked at the issue around 3.2, which was explaining the rights of members in voting, because that's a big part of private limited and public limited company and how that affects individuals. We looked at ordinary resolutions and special resolutions. We also looked at proxy voting and electronic voting, which is becoming more and more advanced. We also looked at voting by show of hands against the poll, and in general meetings, how voting can be conducted either by show of hands or poll. We then went on to look at 3.3, which was to analyse minority shareholder protection and what that means and what it refers to, like the legal safeguards and things like mechanisms to protect the rights and interests of minority shareholders, because they don't have a huge amount of protection for them. We also went on to look at the legal framework around that in many jurisdictions. The laws are different for minority shareholders, so we looked at that. We also looked at the rights of information and inspection. We then went on to look at the protection against oppression, how minority shareholders are treated unfairly by majority shareholders or company directors. We also looked at minority veto rights, and then went on to look at derivative actions and exit rights and remedies for minority shareholders. So here we looked at learning outcome 3. Overall, we looked at the member voting rights, classification of shares, variation of rights of shareholders, and we looked at minority shareholder protection in regards to how majority shareholders are more protected than minority shareholders, and looked at the elements of where protection can be available for minority shareholders and where they have, more rights, and how they could be safeguarded, or any sort of remedies that could be put in place to promote any sort of confidence and integrity and fairness of the company's operation, because it's unfair if they are treated unfairly, even though they are minority shareholders. We also looked at their rights and their legal framework around minority shareholders. Now we're going to go on to learning outcome 4, which is looking at understanding the legal procedures related to corporate liquidation. So the learning outcome for the indicative content is that we're going to look at directors, responsibilities to creditors, corporate governance, legal procedure, and related to corporate liquidation, differences between administration and liquidation of a company. I've got a video there that you can look at in your own time, and it looks at the issue around liquidation of a company and the procedure and how long it could take. We're moving on to 4.1, which is to evaluate the role of the auditor. So the role of the auditor in the context of corporation liquidation is critical in ensuring any in ensuring transparency, accuracy, and compliance with legal and accounting standards throughout the liquidation process. And we're going to look at the evaluation and the role of the auditor in this context. But before we do that, we need to identify what liquidation is, so at least you have an idea. The liquidation process is actually where you would see a company wound up, closed down, and struck from the company's house register. Liquidation commonly occurs when a company can no longer pay its debts, resulting in company assets being sold off in order to pay creditors. The liquidation process can be voluntarily or it can be court-ordered, with the end game in either case being to liquidate the company. So the looking at the role of the auditor in context, so we've got independent verification. Auditors provide verification of the company's financial statements, ensuring that present and a true fair view of the company's financial position and performance. During liquidation, auditors verify the accuracy of the company's financial records, including assets, liabilities, income, and expenses, to ensure that they are fairly presented and free from material misstatement. In performing the role, the auditor is required to report on the adequacy of the company's accounting records, as just mentioned, and where the financial statements, given any sort of importance to the liquidator of a company's accounting records for investigation purposes, the auditor's view on the same will be relevant. So the auditor needs to report to the annual statutory financial statements and compliance applicable to the accounting standards disclosure requirements. So assessment of going concerns. Auditors assess whether the company is a going concern, meaning it has the ability to continue operating in the foreseeable future. In the context, the liquidation, auditors evaluate the company's ability to continue operating and meet its obligation as they become due, providing insights into the financial viability and the need for liquidation. Auditors are responsible for, so the next one is detection of fraud and misconduct. Auditors are responsible for detecting and reporting fraud, errors, and misconduct that may impact the company's financial statements. During liquidation, auditors scrutinize the company's financial records for any indications of fraud or irregularities, because identifying potential misappropriation of assets, improper transactions, or breaches of fiduciary duties by the company's management. The auditor is a special position in relation to a company being no ordinary third party. He or she is a person falling in the scope of Section 235 of the Solvency Act 1986, owing mandatory statutory duties to cooperate with the liquidator. So the review and asset realization and distribution. So auditors review the realization of the company's assets. And the distribution of funds to creditors and shareholders to ensure compliance with legal requirements and equitable treatment of stakeholders. They assess the fairness and accuracy of asset valuations, sale proceeds, creditor claims, and shareholder distributions, providing assurances that funds are distributed in accordance with statutory priorities and the company's articles of association. Compliance with legal and regulatory requirements. Auditors ensure compliance with appropriate applicable legal and regulatory requirements governing financial reporting, disclosure, and corporate governance. During liquidation, auditors assess whether the liquidation process adheres to legal requirements, including those related to creditor notification, asset realization, creditor payment, and distribution of remaining funds to shareholders. Communication with stakeholders. Auditors communicate with stakeholders, including shareholders, creditors, regulators, and liquidators, providing assurance regarding the accuracy and reliability of financial information and the integrity of the liquidation process. They may issue reports or opinions on the company's financial position, the effectiveness of internal controls, and the fairness of liquidation process, enhancing shareholders' confidence in the integrity of liquidation proceedings. From the perspective of a liquidator seeking to investigate and unscramble a company's financial affairs and dealings, the auditor's working papers or audit evidence can often be vitally important source of financial information, as we just mentioned, which can assist a liquidator to efficiently understand the structure and breakdown of numbers contained within the financial statements. In conclusion, in summary, the role of the auditor in a corporation liquidation is multifaceted, encompassing independent verification, assessment of going concern, detection of fraud and misconduct, review of asset realization and distribution, compliance with legal requirements, and communication with stakeholders. By providing assurance and oversight, auditors play a crucial role in promoting transparency, accountability, and confidence in the liquidation process, safeguarding the interests of creditors, shareholders, and other stakeholders. Now we're going to go on to looking at 4.2, which is analysing the winding up process and dissolution, including powers and duties of the liquidator. So firstly, analysing the winding up process and dissolution, including the powers and duties of the liquidator, involves understanding the legal framework and procedural steps involved in winding up a company's affair. Firstly, I'm just going to identify to you what winding up is, and it's a process of liquidating a company. While winding up a company ceases to do business as usual, its sole purpose is to sell off the stock, pay off the creditors, and distribute any remaining assets to partners or shareholders. Winding up refers to the process of, as I mentioned, to liquidating assets. Winding up a business is a legal process regulated by corporate laws, as well as by a company's articles of association or partnership agreement. Winding up can be compulsory or voluntary and can apply to publicly and privately held companies. So here's an analysis. Commencements of winding up. So winding up may commence voluntarily by the shareholders of the directors or involuntary, as I've just mentioned, by a court order. In the voluntary winding up, a resolution is passed at a general meeting of shareholders to appoint a liquidator and authorize the commencement of winding up proceedings. And in some cases here, personal liability for the company's debts. Even if it is solvent, the shareholders may feel their objectives have been met and it's time to cease operations and distribute the company assets. In other cases, bank market situations may paint a bleak outlook for the business. So if the stakeholders in voluntary winding up decide the company may face insurmountable challenges, they may call for a resolution to wind up the business. Then we've got compulsory winding up. And in compulsory winding up, a court issues a winding up order based on grounds such as insolvency, inability to pay debts, or just unequitable grounds. And this is, as we mentioned, a company can be legally forced to wind up. The company is ordered to appoint a liquidator to manage the sales of the asset and distribution of the proceeds to the creditors. The court order is often triggered by a suit brought by the company's creditors. They are often the first to realise that a company is insolvent because their bills have remained unpaid. So in other cases, the winding up is the conclusion of bankruptcy proceeding, which can involve creditors trying to recoup money owed by the company. So we've got appointment and powers of the liquidation. So liquidator, upon commencement of winding up, the liquidator is appointed to oversee the liquidation process. The liquidator may be a licensed insolvency practitioner or an official receiver appointed by the court. The liquidator has extensive powers and duties conferred by law, including the power to realize the company's assets, settle its liabilities, distribute funds to creditors, and close its affairs. The liquidator has the authority to investigate the company's affairs, recover any assets, commence legal proceedings, and take actions necessary to wind up the company's business in an orderly and efficient manner. Realization of assets. The liquidator identifies, collects, and realizes the company's assets, which may include cash, property, inventory, equipment, and intellectual property rights. Assets are typically sold or disposed of through various methods, such as private sale, auction, or tender, with the proceeds used to repay creditors and cover liquidation expenses. Settlement of liabilities. So the liquidator assesses the adjudicates creditors' claims, determining the validity and priority of each claim. Liabilities are settled in accordance with the statutory hierarchy of creditor claims, which typically prioritizes secured creditors, preferential creditors, and unsecured creditors in the distribution of funds. Distribution of funds. So once the company assets have been realized and its liabilities settled, the liquidator distributes the remaining funds to creditors and shareholders in accordance with their entitlements. Creditors are paid in the order of priority prescribed by law, with the remaining funds distributed to shareholders in proportion to their shareholders, subject to any preferences or priorities established by law or the company's articles of association. Finalization and dissolution. So after all assets have been realized, liabilities settled, and distributions made, the liquidator prepares final accounts and reports detailing the liquidation process. The liquidator convenes final meetings of shareholders and creditors to seek approval of the final accounts and the dissolution of the company. The company is then dissolved, ceasing to exist as a legal entity, and its name is struck off the register of companies. So in conclusion, in the summary, the winding up process and dissolution involve a structured series of steps and procedures overseen by the liquidator, who has extensive powers and duties to realize the company's assets, settle its liabilities, and distribute funds to creditors and shareholders in accordance with the law, by ensuring compliance with legal requirements and facilitating an orderly winding up company's affairs. The liquidator plays a crucial role in the dissolution process, safeguarding the interests of creditors, shareholders, and other stakeholders. Now we're going to look at 4.3, which is to assess the priority of creditors in winding up process. So assessing the priority of creditors in a winding up process involves understanding the hierarchy of creditor claims and the order in creditors are paid. When individuals and businesses owed money by a company are known as creditors. So if the amounts they are owed are repaid and the company has been liquidated, any unpaid debts remaining at the end of the process are written off. In a solvent liquidation, creditors are grouped into categories that determine the position and the payment hierarchy. This is statutory order of priority set out in the Solvency Act 1986, and the liquidator is obliged to make payments in order. So you've got secured creditors. Secured creditors hold security interests or charges over specific assets of the company, such as property, equipment, or inventory. Secured creditors have the highest priority in the winding up process and are typically entitled to be paid from the proceeds of the sale of the secured assets before their other creditors are paid. If the proceeds from the sale of the secured assets are insufficient to satisfy the secured debt in full, the secured creditor may have a claim against the company's remaining assets as an unsecured creditor for the shortfall. These are secured creditors. These are generally banks and other asset-based lenders that hold a fixed charge over the asset in question. Vehicles, for example, property or land, the lender is entitled to recover possession of the asset insolvency of the company, with fixed charge being registered with Companies House. You also have secured creditors with a floating charge, and this means creditors holding a floating charge over the company's assets are next in line. Floating charges are held over an asset class, so could include stock, work in progress, and raw material. Floating charges are also registered with Companies House by the lender. When a company enters insolvency, the floating charge crystallizes to become a fixed charge. Then we've got preferential creditors. Preferential creditors are entitled to include priority payment over unsecured creditors, but rank behind secured creditors. Preferential creditors include certain categories of creditors specified by laws, such as employees for unpaid wages, salaries, and certain employment-related liabilities, as well as government agencies for unpaid taxes, social security contributions, and other statutory obligations. Preferential creditors are typically paid in full before any distribution is made to unsecured creditors, but may not feel but may not receive full payment if the company assets is insufficient to satisfy all the preferential claims in full. Some employee payments in liquidation are regarded as preferential, including things like notice pay and redundancy claims. Claims for these payments are regarded as unsecured. The next one is unsecured creditors. Unsecured creditors are creditors who do not hold security interest or preferential status and are therefore entitled to be paid from the company's remaining assets after secured and preferential creditors have been satisfied. Unsecured creditors include trade agreements, suppliers, contractors, lenders without security interest, bondholders, and other general creditors. Unsecured creditors rank equally among themselves, and they are typically paid on a pro rata basis from the remaining assets of the company, with each creditor receiving a proportionate share of the available funds based on the size of the claim. They can also be unsecure creditors with a connection to the company, and sometimes this is family members, friends, and other individuals with a personal connection to the liquidated company are owed money by the business, but this group are only repaid when other unsecured creditors have been paid in full. Next one is subordinated creditors. Subordinated creditors are creditors who have agreed to subordinate their claims to those of other creditors, typically through contractual agreements or subordination provisions in a loan agreement or bond indentures. Subordinated creditors rank behind all other creditors in the winding up process and are entitled to be paid only after all other claims have been satisfied in full. Shareholders. Shareholders are the owners of the company and rank last in the hierarchy of creditor claims. Shareholders are entitled to receive distributions from the company's remaining assets only after all creditors have been paid in full, including secured creditors, preferential creditors, and unsecured creditors. Shareholders may not receive any distribution if the company's assets are insufficient to satisfy all creditor claims, in which case they may incur a total loss of their investment. As we mentioned, company shareholders are placed at the bottom of priority list in liquidation and really receive anything, in regards to that. It's one of them things where creditors would, the rest have to all be paid before shareholders are given any sort of money, to help with any sort of, you know, they're right at the bottom of the list. So, it's very important that, the others are paid before them. In conclusion, the priority of creditors in a winding up process is determined by the legal hierarchy. Of creditor claims, with secured creditors having the highest priority, followed by preferential creditors, unsecured creditors, subordinated creditors, and shareholders. Understanding the priority of creditors is essential for ensuring fair and equitable distribution of companies' assets and protecting the interests of stakeholders in the winding up process. The Insolvency Act 1986 lays down the order of priority a licensed conveyancer practitioner must follow to pay the creditor's claims, and we mentioned above the hierarchy. The company's assets are sold for the benefit of the creditors, but creditors are grouped into specific categories, as we mentioned earlier, from the hierarchy from the creditor claims, with secured creditors down to shareholders. And this typically means that the creditor falling at the bottom of the priority list receives little or no return for administration, as we mentioned, in regards to the shareholders receiving nothing. The office holder gathers in the company's assets for realization, obtains a professional valuation, invites claims from the company's creditors. When all monies are received from the following sale of assets, the administration or liquidation can begin to repay claims to creditors. As creditors must be paid in full, as in the group, from secured down to shareholders, the knock-on effect to other businesses can be severe. Suppliers and other unsecured creditors in this position typically receive no dividend from the process and can experience a decline themselves as a result of unpaid debts and the loss of their customers. So it's quite upsetting that they have to go through this grouping, but this is how they are paid because they are unsecured or secured. 4.4, evaluate the role of licensed insolvency practitioners. So licensing insolvency practitioners play a crucial role in the context of corporate solvency and liquidation process. Sometimes it's referred to as IP, will act on behalf of the company and individuals when they are facing insolvency or acute financial distress. Licensed conveyancer is also able to help directors of solvent companies who have chosen to liquidate their companies by way of members voluntary liquidation (MVL) in order to extract held profits. In the majority of cases, a company director will voluntarily approach a licensed insolvency practitioner and enlist their help in dealing with distressed company. In matters of compulsory liquidation, the courts will appoint an official receiver who will act as the provisional liquidator, and they may later request an insolvency practitioner to be appointed to take liquidation forward. So the expertise and qualifications. Licensed insolvency practitioners, professionals with specialized expertise in insolvency law, accounting, finance, and corporate restructuring. They undergo rigorous training and accreditation processes to obtain their licenses, ensuring that they possess the necessary knowledge, skills, and experience to effectively manage insolvency proceedings. The appointment and oversee. So licensed practitioners, IPs are appointed to oversee insolvency processes, including administrations, liquidations, and voluntary arrangements. The appointment may be voluntarily, but the company's directors or shareholders are compulsory by creditors or the court. IPs are subject to oversight by regulatory bodies such as the Insolvency Practitioners Association (IPA) in the UK, which ensures they adhere to professional standards and ethical guidelines. The role in administration. So in administration, IPs act as administrators, assuming control of the company's affairs and implementing restructuring plans to maximize returns to creditors and rescue the company as a going concern. They assess the company's financial position, develop restructuring proposals, negotiate with stakeholders, and oversee the implementation of restructuring measures such as assets, sales, debt restriction, or business reorganizations. Their role in liquidation is to act as a liquidator responsible for winding up company's affairs, realizing its assets, settling its liabilities, and distributing funds to creditors and shareholders. They assess creditor claims, investigate the company's affairs, realize assets, adjudicate creditor claims, and oversee the distribution of funds in accordance with legal priorities. The protection of stakeholder interests. IPs have a duty to act in the best interest of all stakeholders, including creditors, shareholders, employees, and other affected parties. They balance competing interests and seek to achieve fair and equitable outcomes for all stakeholders while fulfilling their legal and fiduciary duties. Communication and transparency. IPs communicate with stakeholders throughout insolvency processes, providing updates on developments, seeking input on key decisions, and addressing concerns and queries. They maintain transparency and accountability in their actions, ensuring that stakeholders are informed and involved in the process to the extent possible. Conflict resolution and mediation. IPs may facilitate negotiations and mediate disputes between stakeholders to reach mutually acceptable resolutions. They use their expertise in insolvency law and corporate finance to navigate complex situations and find pragmatic solutions to contentious issues, avoiding protracted litigation and maximizing value for stakeholders. Insolvency in the UK is regulated under the Insolvency Act, and the IPs are subject to regular inspection, as we just mentioned, by the governing body. There are several professional bodies, including IPA, as we've just mentioned, ICAEW, and ACAS. All, however, adhere to the same strict standards of performance levels of professional conduct. Cost of employing services of insolvency can range around the region of £5,000 or slightly less. Many directors will be recommended the services of insolvency practitioner from their accountant. And to get an insolvency practitioner, you know, the government have a database that you can search to try to get any sort of allows you to get, you know, an insolvency practitioner based on the location. So in conclusion, in summary, licensed insolvency practitioners play a vital role in corporate insolvency and liquidation processes, leveraging their expertise, experience, and impartiality to navigate challenging situations, protect stakeholders' interests, and facilitate orderly and efficient resolutions of insolvency proceedings. Their role is essential in maintaining confidence in the insolvency regime and preserving value for creditors, shareholders, and other affected persons. Okay, so we've finished learning outcome 4 now. The references we've used for today are just listed there, which you could use and look at in your own time. So we've got Corporate Insolvency Law by Finch, Key Corporate Insolvency Law, Corporate Bankruptcy Law by Bade, Payne Corporate Insolvency Law. Then we've got another list there, which is some good resources and journals that you could use to help support you when completing the assignment. And we've got the Modern Law of Directors, Duties by Mead, Seeley, Cases, Materials in Company Law, and Thompson, Company Law and the Incorporated Business Ethics. There's also further reading for you to go on to Moodle for any ebooks and journals on Moodle that you need to refer to. Any further reading, any sort of additional resources will be available on Moodle. Any queries you have, please email learnerwork@ukvarsity.com. .co.uk. Submission of assignment is to do on learnerwork@ukvarsity.co.uk, and submission is 2 weeks of the completion of the unit and its delivery. So we've got the next session we've finished learning outcome 4 now. The next session is the assignment discussion. Thank you for attending the session, and I will see you in the next session, which is the assignment discussion. Thank you.